So what we try to do is sort of start kind of right at the beginning when the need for help and support first begins. And I've been doing this role now for 35 years, and I am still astonished how few people know about the benefit system and how it interacts with people with a care need, in particular, um, attendance allowance, which is such a critical benefit that has a huge impact when people are initially dealing with a care need. And the reason it causes such confusion is because it doesn't feel like a normal benefit. And by that, I mean, and this is what causes the confusion, it is not means tested. So it doesn't matter how much income you have, it doesn't matter how much savings you have. If you qualify, you will get attendance allowance. And I had an argument with a doctor about 6 months ago who came onto the helpline, absolutely adamant that his mother couldn't claim attendance allowance because she had too much savings. So it just shows you how people misunderstand how you would qualify for something. The second thing is that it's equally confusing is you don't have to be attended, which usually most people think, well, how can that make sense? You don't have to be attended. You merely have to demonstrate the need to be attended. Whether you do so or not is a separate matter. And that really is the key point about attendance allowance. You can use it for whatever you like. I've met people who've used it to pay for taxis to get them to do their shopping, for cleaners to come in and do those awkward bits up above the helmet that you can't reach yourself. You can use it for absolutely anything that you want that helps you to cope with your particular condition, whatever that may be. And one of the most extreme examples of that is if you have, for example, eyesight problems, macular degeneration would be the obvious one. You can actually claim attendance allowance so that somebody can come in and read your post because you can't do it. So it is a very wide-ranging benefit, much misunderstood. People just think, oh, I'm not ill enough to qualify, or they think it's means tested. But that's not the case. Only qualifying rules are you must be over 65. If you're 65 or under, then you would qualify for PIP. And two particular conditions that are important. The most important one is you must have had the condition that creates the need for attendance for at least 6 months. And the purpose of that is not to be awkward, but to avoid claims being made for temporary issues. So, for example, if you come out of hospital and you're in that period of convalescence, then attendance allowance is not the benefit designed to help you with that, because the idea would be that you would recover and everything would be fine. So if you've had it for 6 months and the condition has not gone away or not improved, then you would qualify. There are two levels at which you can receive it, generally referred to as the lower and the higher rate. The lower rate is now £76.60 a week, so not means tested and not taxable. And that is for somebody who needs, the definition is frequent help or constant supervision during the day or supervision at night. And the higher rate, which is now £114.60, is for people who need help and supervision both during the day and night. Now, those descriptions I don't think are particularly helpful, because you read that and think, I don't need frequent and constant supervision. It sounds a bit onerous. You will be surprised at the conditions that will qualify. You just need to have a situation where somebody needs to come and assist you. There is no definition of frequent, and there is an argument about what constant means. So don't be put off by that. Make a claim and see what reaction you get. Now, there's a particular section on the form that I think is the most important bit of the application, which is about the medication you're on. From the point of view of the person assessing your need, medication can be the clearest indicator of what your problems are. So make sure you fill it in correctly. And if need be, I've even, in my own situation, for family members, taken that to the doctor and said, well, you just complete this section, just to make sure that you get what you're entitled to. If you need more information, I have to say Age UK have probably the best fact sheet on attendance allowance. It's quite extensive, well worth a read, and tells you everything that you would need to know. You can apply online, so you don't have to go through too much of a process in terms of completing the form. One thing to mention is you can't receive attendance allowance if you're in hospital. So if you get admitted to hospital, the government's view is you can't get help twice. You can't get help through the NHS when you're in a ward and receive attendance allowance. So you might have a period where that would temporarily stop. And that same idea applies to if your care is being funded by the local authority, then you can't claim attendance allowance, the government's view being that you can't have both. But to me, it is the most important benefit, not only because of the value it brings. £114 a week can make a heck of a difference. I have loads of examples of how that works. One lady I was speaking to had not realised that her husband could qualify for that, and we were able to direct them so that she did. They used the money so that her husband could be picked up and taken to a day centre once a week, just to give him a break and to give her a chance to have a bit of time on her own. And without that money, that wouldn't have been something that they could have considered. So it can make a massive difference. So my advice to you is make a claim and be rejected rather than sit there thinking, might I or might I not? The other thing to bear in mind, it's what they call a gateway benefit. You'll find lots and lots of other benefits open up to you because you've got attendance allowance, because you've demonstrated that need for extra help. So for me, I do a quick check on the number of people that call us who are involved in a care situation, and I would think at least 40% still don't have attendance allowance in place. So it's absolutely crucial. Now, if you've got it, that's fine. As I say, these are just taster sessions to sort of make you aware of what's available. The next one I want to come along to is kind of grown in importance recently, and this is carers allowance. Let me just take you through the details. It's paid at the rate of £86.45 a week, which is not a huge amount of money, I agree. And you get it if you care for someone for at least 35 hours a week, and that person gets certain benefits. Attendance allowance is one of them, PIP is another. Now you might think, well, 35 hours a week, that's like a full-time job. But I speak to lots of people. If you sit down and add up all of your caring duties, then it's not difficult to get to 35 hours a week, because it includes everything from shopping to cleaning to taking somebody on an appointment. The person that you're claiming this for doesn't have to be related to you. You don't even have to live with them. It's just anybody who you care for. You don't get any more money if you care for two people. Unfortunately, it's a one single amount. And if two people care for the same person, only one of you can claim carers allowance. So as I say, when you think about the jobs that make up that 35 hours a week, washing, cooking, taking them to an appointment, helping with household tasks, managing bills, shopping, all of that counts, because that's help and support that you're providing. Now, the qualifying rules for the person making the claim are important in that you must be over the age of 16, but you must not be in receipt of the state pension. So this is a fairly narrow group of people in my experience. It tends to be ladies who are caring for a relative, usually mum or dad, and they're in that sort of age group of 50, 55, but not yet in receipt of their state pension. Excuse me. And the reason it's important is that to qualify, you have to be earning less than £204 a week, which again is a very modest amount. It has gone up. It used to be 150. Over the last 2 years, they've increased it dramatically. But let me just explain how people are using this. The rules that calculate the £204 state expressly that that does not include any private pension. So what we're seeing is people in that age group, particularly 55 and onwards, who are forced effectively to take a reduction in their working hours because they're caring for mum or dad. So they go to their employer and say, can you get my hours down so that I earn less than the £204 a week, because that means I can then claim attendance allowance, which doesn't actually give them as much money as they want to live on. So they draw money from their private pension because that isn't included in the £204 a week calculation for some reason known not to me, but that's the rule. So I've met lots of people who are taking reduced hours at work, getting their earnings below that figure, claiming their carers allowance, and then topping up their own income so that they can meet their needs from their private pension. Now, that wasn't common a couple of years ago, but these new numbers, these increases in numbers, will make that quite popular. And it's ideal for that transition where the care need is just developing, the person's having to spend more time caring, less time working, but it does all change when you reach 65 and those rules do change. So something to be aware of if you fall into that category, or you know somebody maybe who does. As far as other benefits, there are lots of them, and it's always difficult to know where to stop. I would just mention two. Pension credit is probably the most important one. It's the most confusing benefit I've ever come across. It's basically the replacement for income support. The best way to find out if you qualify is there are quite a few online calculators. Age UK have one, the government have one, and you can sit quietly and type in the details, and it will kind of tell you whether or not you will qualify without having to work out the whys and wherefores of it. Other things to be aware of, carers credit, that's probably worth a mention. You get carers credit if you're caring for somebody for 20 hours a week, and it basically because you can't earn enough income if you're caring for somebody for 20 hours a week to maintain your national insurance record. The carers credit gives you a top up so that it doesn't affect your pension when you come to retire. So that's worth having if you're in that sort of caring role. So, as I say, there are lots of things out there to get financial help for both carer and the person in care. You've just got to go and find out. And my advice to you is go and book an appointment at CAB or Citizens Advice Bureau or Age UK, and just let them take you through the process of what you can apply for, because it is daunting. You know, the application for pension credit is quite difficult. So get some help, but don't. I do meet some people who say I'm too independent to get this help, and I say that's fair enough. That's a conscious decision on your part, but I hate it when people don't get the money that they're entitled to because they didn't know. So have a look, decide what you want to do, but it can make a huge difference in terms of just helping with the finances particularly during that early care need. Okay. The second area I want to look at, and I won't say it's the more important, all of these things are important, but I wanted to touch on the legal issues that a carer should be aware of. Two in particular. You may think the second one's a little odd, but I want to just talk briefly through lasting power of attorney and wills. Start with lasting power of attorney. Again, we run some records on our helpline about how many of the people who contact us have not yet established or are not in the process of establishing their lasting power of attorney. And it's about 50%. What worries me is that group of people are in the care system, otherwise they wouldn't be ringing our helpline. So I think if you looked at the broader public, it's a much lower percentage, and that is a real problem. In my view, everybody over the age of 18 should have an LPA, regardless of age, regardless of circumstances. This is not something just for older people. Why is that? Because it is the only, and I stress, the only legal way for somebody to provide authority while somebody else to act on their behalf. And without it, the chances are that the institution or the organisation that you're dealing with will not speak to you or allow you to discuss the issues involved. It's a very formal legal process. and it's overseen by the Court of Protection, so it's a pretty serious process. And within that, there is a division called the Office of the Public Guardian. Their job is to stand squarely and fairly behind all those people who may not have the capacity to look after themselves, to make sure that their affairs are handled and managed correctly. So there are two different lasting powers of attorney, and my advice to you will be to always consider both. The first one, the name's fairly straightforward, is property and affairs. So this deals with the authority for somebody to look after money, assets, property, finance in general. The document, when it's completed, must be registered with the court before it can be valid and before it can be used. But it can be set up so that it becomes effective on the day it's established. This isn't something to say, I want this to start when I'm no longer capable. You can set them up so that they begin immediately. And that's an important feature, which I'll explain a bit more about in a moment. The other one is called health and welfare. And as the name suggests, that's to do with everything medical. And again, it has to be registered with the court to be valid. But unlike the first one, the health and welfare power of attorney can only be effective when the person has lost the capacity to make a decision themselves. Part of the reason for that is within the health and welfare power of attorney is a section about making decisions on life-sustaining treatment. So basically, if you are capable of making a decision, then you should decide what happens to you rather than somebody else. So the court's very clear about that distinction. And you will have the option to say, I do want my attorney to have the authority to make that decision. Basically, I do not resuscitate or remove life-sustaining treatments, or I don't. You have that choice. So you can have an appointment that does cover it or one that doesn't. And the reason the courts are brought this in, this is a relatively new concept. I say relatively, probably been in force now 20 years, but they want to avoid these challenges and confusions, particularly you see it with children, where the parents are taking the hospital to court because they have a different view. And by definition, these children do not have these arrangements in place. So they don't want that to apply to older people. So I meet lots of people who only have the power of attorney for property and affairs because they think it's the money bit that matters. But we're seeing an increasing situation where people are being asked for the health and welfare. A good example in care terms is if you were making an admission to a care home. The care home could say, this is a financial transaction because you're signing a contract to pay X, Y, Z of fees. But I've seen some care homes say, no, this is a health and welfare matter because it's to do with where a person lives and how they are cared for. So you're starting to get different views. So my advice is have both. Make sure you've got both in place. I meet some people who appoint different individuals in each of those capacities. For example, one chap just happened to have a son who was a banker, so he was his property and affairs LPA, but his daughter was a nurse, so she had the health and welfare side. It split responsibilities, but that's what he thought would be a good idea. Now, I mentioned before about the LPA for property and affairs being effective immediately. That's because the real relevance of that is I meet lots and lots of people who use power of attorney as a convenience. So, for example, dad's struggling with mobility and there's something got to be sorted out at the bank and they want you to come into the branch. And dad just either can't, doesn't want to, but he's perfectly capable of making a decision. With the power of attorney, you can go and do that for him on his behalf because it's convenient, not because he's lost the capacity to make that decision. So I encourage you not, when you set them up, there's a box you can tick, I don't want this to start until I've lost capacity, or I want it to start immediately. would encourage you to start it immediately, because you never know when that convenience issue crops up. Some people say, but I'm giving them carte blanche authority on day one. Yes, you are. And if you are concerned about that, maybe they shouldn't be your attorney, and you might need to think about somebody else. Okay, so that's the basic rules of them. To set one up, you must have capacity. That's a major issue in its own right, because some people have capacity that fluctuates. Lots of people who are fine in the morning and then deteriorate in terms of their mental capacity as the day goes on, or are good after they've had their medication, or they're not good until a couple of hours after they've had medication. So what you've got to do is you've got to check whether this capacity is fluctuating. If it's gone completely, never to return, then you can't set one up. But if it's there intermittently, then a good advisor will find that moment when they had capacity to be able to sign the documents. Even if 10 minutes later, they can't remember what they've done. That's okay, because they had the capacity to make that decision at that moment in time. As I say, once it's been set up, it has to be registered with the court. There is now I think they've just increased the fee to £92 is the cost of making the registration per document. So there is a cost factor, particularly if you've got two per person and it's two, husband and wife who are setting them up. It is a factor. You can set it up with one attorney, or you can set it up with multiple attorneys, 2, 3, 4 probably. I think you would be probably pushing at the maximum. But common arrangement is mum and dad appoint each other, and that really works for the convenience issue. And then the two children perhaps would step in if required. So you might have 3 attorneys. And you have a choice then about how you give them the authority. Do you give it, there's 2 ways. Do you give it to them jointly? And that means that everybody has to make and agree on a decision about everything, which is not the route I would recommend, mainly because if somebody happens to be on holiday and you need something signed at the bank, you can't, because everybody has to be party to it. The other option is to set things up on what's called a joint and several basis. That means either of the people named can act. Much more sensible, much more practical, because that deals with geography, people working away, people being on holiday. So if you've got more than one attorney, joint and several would be my suggestion. There are 2 other key people in the document. So there's you, or the person making the appointment. Then there's the person receiving the appointment, i.e. the attorney. And then you need to consider 2 other people. And the most onerous job is that of certificate provider. Certificate provider has to state, legally declare on the form that the person who's making the appointment is able to understand, knows what they're doing, and more importantly, isn't being forced to act under duress or pressure from anybody. And a lot of people look at that and think, oh, I'm a bit nervous about signing that. And the system allows for that to be a professional, for example, a doctor, a solicitor, a care, social worker type of person. Most of them are reluctant to sign it because they're worried about their insurance policies, and also they're likely to charge. So the system allows for that to be signed by a friend or a neighbour. Anybody who's known the person for 2 years, that's the only condition, providing they are neither the attorney that's been appointed or related to the attorney, because the whole point of the certificate provider is to provide this independent kind of sign off. So if it's the wife of the person who's getting the power of attorney, the court will decline that. So you just need to be somebody independent. Again, people do get a little bit nervous, and when you read the wording, it's a little bit, official, but you're just saying on that day, Mr. Jones was okay to complete this. And then the final person involved is the witness, which is the person who is simply signing to say, I saw this person put their mark on this document. And the certificate provider and the witness can be the same person, which just makes it easier that you're not having to get kind of extra people involved. And that's it. Once you've completed all that paperwork, you send it off to the court, and if everything is correct and they check everything out, then you get it back, and then it becomes effective. Now, we run a session. This is such a complicated subject. We run a specific session on LPAs that runs for the full hour. So we just covered that in kind of 20 minutes. There is more. And if you have any issues in the meantime, please feel free to give us a ring. I will just mention one thing. If you do not have a power of attorney and you lose capacity, then you have to succumb to the system of deputyship, which is you apply to the court for an order that allows you to do these things. And it's extremely unpleasant and extremely expensive. And they kind of treat you a bit, not say as though you're a criminal, but they take the assumption that dad didn't appoint you to be attorney because he didn't trust you. Therefore, they kind of take a step back, and they can ask you for bonds, and they can ask you for financial security, and they can ask you to submit accounts every year. So the reason I mention it is because you really want to avoid getting yourself in that position. One final thing I would say is that you can write them yourself. You don't have to go and get any professional help. If you can work your way through the forms and follow the guidance that they provide, then it's an online process that you can complete yourself, because there's no advice. You just follow the guidelines that I've mentioned and make the choices that I've outlined. You could alternatively go and do this through your solicitor. You could go to a will writer. That's quite a good option, mainly because they'll come and visit you at home. Lots of people don't like or are not able to go into a solicitor's office in the high street. So a will writer could be an option. But if you haven't got one yourself, please get one. If you know anybody who hasn't got one, tell them to do it. And if you're caring for somebody who hasn't got one, get it set up immediately, because it will save you lots and lots of worries and problems later on. Now, on the issue of legalities, I just also wanted to mention those, which you may think, how is that relevant from a care point of view? Surely that's kind of too late. But I wanted to mention three things that crop up quite regularly. Number one, it's important to have a will and to understand that if you don't have one, then your estate will be dealt with under the rules of intestacy. And I mention this in particular, if you've just found out, this happens quite a lot, if you just found out that dad had never got round to writing a will and has now lost the mental capacity to do so, there is a process where you can get a statutory will through the court. It's quite expensive. But if you just have a look at the intestacy rules, whereby the first 325,000 goes to the spouse, it may be that that works perfectly and you don't need a will. In other words, it's okay to die intestate. So don't go off spending money if the system itself would allow you to do what you want. Where that becomes a problem is where you've got blended families, remarriages, stepchildren. That gets very complicated, because under intestacy, only direct family can inherit. Not unmarried partners or friends or charities will not receive anything. So it's a good argument to say, get your will in place. And I just wanted to mention three things about care wills, if I could call them that. The wills of people who have a care issue. I see lots of wills that simply, they're called mirror wills. It's where mum leaves everything to dad and dad leaves everything to mum. And if anything happens to either of them, it goes to the kids. That's a standard. You see that, I don't know, 75 times out of 100. And that's fine and totally okay. However, just bear in mind that if dad dies leaving everything to mum, and mum then goes into care, she will be assessed as having all of the family wealth in her name. In other words, you've created a concentration of wealth, which means that local authority, Gloucester County Council, will be able to not provide funding support until that capital has been eroded down to the 23,250 mark. So how might you protect yourself from that? Well, one option is to, sounds terrible, for husbands and wives to disinherit each other. Don't leave your share of your estate to your spouse. Leave it to the family, will be one option. Probably better still a trust, and we could spend a whole session on that. And we do a session on wills in detail. But basically what you're doing is you're leaving your share of your estate to somebody other than your spouse, so that if they then need care, that money is not taken into account. It's ring-fenced effectively with somebody else. And that can help to pay for top-up fees and all sorts of things. So if that's something, that situation that you might be in, please give us a ring or come along to one of our sessions on the specifics of wills. Now, in order to, I'm going to deal particularly with property because it's the most common issue. Property quite often is held jointly, which is the old school way of doing things. So if mum and dad have had their house for quite a long time, the likelihood is that they will own it jointly. And the rules are that anything you own jointly, regardless of what you write in your will, can only be passed on to the other joint owner. Think of a bank account. If you've got £10,000 in a joint account, husband and wife, and husband dies, then that money can only go to the spouse because it's a joint account. They own it together. Well, the same thing applies to property. If you own it jointly, regardless of what you've said in your will, so what you have to do is go and check how the property is owned. You can do that through the deed, through your solicitor. You can give us a ring, and you can find it through the land registry. And if you do own it jointly and you want to pass your share to somebody else, you have to change it to something called tenants in common, which sounds complicated. It's not. You have to sever the joint tenancy and create a tenants in common. It's a one-page piece of paper, very simple to do, and it then allows the will to be changed so that you don't get this concentration of wealth. I focused on property, but it would apply to everything: cash, savings, anything that you own together. The other thing I would mention about care wills is I quite often see people who have listed bequests to their grandchildren quite often. And they may have said, I'm going to leave £25,000 to be distributed to each of my 5 grandchildren on my death. And when they wrote the will, they were fine, fit and healthy. They had savings and they had a property. But of course, by the time the will is applied on death, they could well have spent most of that money on a care need. And I had one only 3 months ago where exactly that clause had been put in, which is why I've taken it. But at the time of death, the lady had £32,000. So the first 25,000 went to the grandchildren and the balance went to her daughter, which was not her intention. She intended that the grandchildren would receive a small amount and daughter the bulk. But because she listed the amount, that didn't work out. So my advice to you is list the figures as percentages. I leave 10% of my estate to my grandchildren equally, and 90% the balance would go to my son or my daughter or my children, so that that change in asset doesn't require you to change your will and doesn't create the wrong kind of distribution of money. So those are the only 2 things I'm going to mention on legals, but they are important. And as I say, it's just a taster to get people thinking about what they might do. So the third area I wanted to talk about today, as an introduction, and because it's Carers Week, we're running a care funding session tomorrow for an hour on just that subject. So I wanted to give you a taster on that. We've all in a situation where we've been waiting for the reforms to kick in. We had the reforms with the last government that were cancelled, and we've now got the Care Commission in place, but isn't going to report for quite some time. No idea what they're going to say, and no idea whether the people in power will do anything about it. So currently our system remains in place as it is. It's extremely complicated, grossly unfair, but we have to deal with what we've got. So two thresholds that are the key financial measure. Most people are familiar with the 23,250. If you have money over that figure, then basically you will not get any help from the state. There is a lower threshold, which is 14,250. If you have savings below that figure, then you will not be expected to make a contribution because of your assets. And if you have a figure between the two, you have to make a contribution. It's a complicated little process, but it basically works out to about £30 a week that you would have to pay purely because you've got savings. Now, our system requires that you are assessed in two ways. The first one is a assessment of need. So if you're looking for help from the state, from the council, then they will first of all assess your need. Should you be in a care home? Should you be at home? Do you need 1 visit a day, 3 visits a week, or 4 visits a day? What is your care need assessment? And once that's been worked out, then the second part is to say, okay, we now know what you need, who's going to pay for it? So that brings in the financial assessment. And at that point, they go through all the process. Now, as I say, we could spend upwards of an hour and a half on this one subject quite easily. So I don't want to go through it all again today and do it tomorrow. But I just wanted to pick out a couple of examples, one for home care and one for care in a home, being the two distinct issues. So if your situation is that you need care at home and you've got more than 23,250, then it's up to you effectively to arrange the care that you require and that you want, rather than what the council social worker may think you want. Because it is ultimately a matter of opinion. So one person says you need 2 visits a day. Some people say, well, I need 4. There's also a bit of an argument about how long these visits last. You know, it's supposed to be half an hour. They end up being 15 minutes because carers are under pressure. But basically, that's how the process would work. Now, if your savings are less than 23,250, then the council will say, yes, we're happy to assist, but they will assist based on the assessment of need that they have determined. So if they've said 2 hours, 2 visits a day, then that will be the amount that they contribute towards. And the idea is that you would pay a contribution to that figure, and it would be based on your overall financial circumstances. You've still got the house to run, you've still got to live. So for most people who have limited savings, their contribution in that situation would be quite small. But if you had, and you do get this now, people who have very little cash or investments, but have a sizable pension because they've worked for the police force or the NHS or wherever it might be, then their contribution to their home care could be higher if they've got an income surplus just in terms of day-to-day living. So it's very much a case of finding out how the system applies to you specifically. If we consider the situation of a care need in a care home, the same rule applies, 23,250. Now, in order to arrive at that figure, the house has to be dealt with. The house will not count towards that 23,250 if it's being occupied by a spouse or anybody over the age of 60. But there are some quite complex rules. And again, the same process applies. You're assessed on your income below that figure. Now, the difference here is that all of your state pension and any benefits that you receive will be expected to be used towards your care fees in the care home. You'll be allowed to keep a small amount called the person expense allowance, which is basically pocket money for toiletries and hair, that sort of thing. The one important exemption is private pensions. The person who's going into care with help from the council and has a private pension, they are allowed to pay half of that private pension to their spouse. and therefore only the other half is taken into account for their care funding. So that's an important option, because quite often with a care in a care home need, the person who has the greatest problem, if there's a couple, is the person who's left at home, because they've still got pretty much all the same expenses, but they haven't got the same income, because husband or wife's, particularly the husband, who might have a larger pension, that money is redirected to the care home. Our system says the person who remains at home would claim benefits in their own right to reflect their reduced income. That's how that's expected to be dealt with, but that has a much more significant impact. So you've got to think ahead as to how that might work, what it will mean. My advice is, don't make a decision about a care placement unless you've thought through what your funding journey will look like. And the main reason I mention that is that the council in care homes will only pay fees at the rate that they think is appropriate to the need. And quite often the care home charges more. So it's not uncommon to see a local authority rate of £850, £900 a week. That's what we would pay for residential care, but the care home's charging £1,200. And if you move into that type of environment under your own steam and then subsequently become dependent on the state, the care home is likely to say somebody has to pay the difference as a top up. And the law says that that person cannot be the resident. It has to be a third party. So we come across this a lot. People make placements into care homes because they want the best care home for their loved one that they can possibly get, but they don't think through what the longer term position will look like. Now, if you've got £1 million in the bank, it doesn't matter. The likelihood is that you will be able to pay for your own care pretty much indefinitely. But if you've got a chance of seeing your capital deplete down to that 23,250, then these are things you have to just have a think about. And as I say, I'm not trying to plug our session tomorrow, but I'm trying not to duplicate the same thing on sort of multiple days. And my final session is really just a help and support thing. It's just a random selection of things that you probably know, but might not know, and you might find them useful. Blue badges, the simple one. Get your application in, because it can make a world of difference. It's difficult enough to park if you're fit and able. So if you've got an entitlement to a blue badge, please use it. Don't forget things like council tax relief for people suffering from dementia. And of course, the definition isn't dementia. It's a much broader definition. But, you know, if you've got a couple, living in a property and one of them has a diagnosis of severe mental impairment, which is the actual title, then you will get a 50% discount on your council tax. And if that's a person living on their own, they will get 100%. So these are just little things that you might be aware of. I am particularly keen on making sure that we focus on carers as well as the person with the care need. That's really the whole point of Carers Week this week, is to try and raise awareness about that. So I would always encourage you. The stuff out there is truly amazing. There is so much help and support, but you have to go and look for it. I will just mention one just to illustrate my point. I was in Devon a couple of years ago, and I was at a conference and I met these ladies and we just got chatting, and she said, I said, what do you do? She said, I run the Totnes. She said, we call ourselves the granny sitting service, which sounded a little, kind of. I said, what do you do then? She said, well, we've all been carers for our parents and our loved ones, and they've passed away. And we kind of realized that there was this huge hole in our lives. We didn't know what to do with ourselves because of the time. And we all got together over coffee and realized that the one thing we could have all done with when we were in that situation is somebody just to come and sit with mum for a couple of hours, because we wanted to go out for lunch with a friend, or we were attending a 50th birthday party, whatever it was. So they set up exactly that organisation, volunteers running around the town, come in and sit in with mum just because she might need a bit of company, so you could do something. So I give that as an example because they have no money to promote themselves. They don't necessarily have a website, but they're out there in every community. And if you can go and have a look, and I have to say the Carers Hub in Gloucestershire is a fantastic service for just this. Not every council has this. They don't all fund this service. So be aware that you're lucky to have that. They can give you access to all this sort of information. Companionship's another one. I was speaking to a lady who had set up an organisation, and it was just called Just Company. And I said, "What do you do?" She said, "Just Company." And she finds people who, the one she told me, which is, I guess, just the one of the day, she had a chap who had an interest in Victorian architecture. I get a strange interest, but his wife he didn't drive, and his wife used to take him to the Ribblehead Viaduct in Yorkshire and all these various places. And she passed away and he couldn't drive. So he went to this agency and they put an advert in the paper to say, is there anybody who might want to, has an interest in this particular subject, who might want to help out? And she got 24 replies to one advert. So the idea was that the chap paid for the day out to the agency. She covered her costs out of that and then paid the difference to the chap who came to pick him up. And he used to bring, I think he became friends over months and went out with a packed lunch and picnic. And it just made the world of difference for a chap who otherwise would have been sat in on his own. So they're all out there, day centres, people who will pick up your loved one and take them for the day so that you can have a day of rest and relaxation yourself. Because if we don't care for the carers, then they won't be able to do the fantastic job that they do. And I would just finish by mentioning a couple of kind of more professional sources. I'll start with ourselves, the Care Advice Line. We've been commissioned by Gloucester now for 12 years just to provide help, support, and information through this complicated service and system that we've got. The great thing about GCC is that they pay us to do this so you don't have to. And I think that is a great resource at just trying to raise awareness. The last two I'll mention is SOLA, the Society of Later Life Advisors. So if your needs are particularly financial and you want help, then you will find, if you go onto the SOLA website, SOLLA, Society of Later Life Advisors, you can search for an advisor in your postcode area and get a selection to choose from. So these are people who are normal financial advisors, but have demonstrated their specialism in dealing with later life matters, powers of attorney, equity release, all the things that care funding. So that's a useful resource. And the final one is Lifetime Lawyers. They're the same thing for solicitors. So solicitors who have a particular speciality in things that affect older people or vulnerable people or people with disabilities. There's lots of them around the country. There's lots of them in Gloucester. And it just means you're going to a specialist rather than a GP, if you see what I mean, on your particular needs and issues. So there's lots of help out there. Take advantage, go and have a look, ask lots of questions, and it can make a real difference to you making informed decisions about kind of what it is you do next in providing your care support for people. So that's me done.